Hello everyone, and thanks for taking the time to watch this webinar about undertaking electronic conveyancing transactions. My name is Laura Orbison. I am a graduate officer placed with the Office of the Registrar General, and I will be presenting to you on the topic of certifications. The Registrar General has nominated the 3rd of August 2020 as the date for the mandating of electronic conveyancing, or e-conveyancing, in South Australia. This will cover approximately 92% of dealings, with additional dealings included as they become available electronically. For a current list of all dealings that are exempt from the e-conveyancing mandate, please see the Land Services SA website. To assist industry in the transition to full mandating, the Office of the Registrar General issued a survey to better understand what support practitioners would like. This short webinar is in response to that survey, in which stakeholders told us they'd like more information about certifications. Section 273 of the Real Property Act requires certain certifications to be given for an instrument to be registered. Similarly, Participation Rule 7.10 requires particular certifications to be provided upon electronic lodgement. The ARNECC Guidance Note No. 3 on certifications provides advice to subscribers on the certifications required when signing documents in accordance with version 5 of the Model Participation Rules. Guidance is provided on the following topics. What are certifications? Certifications are statements made by a certifier that they have undertaken a specific action. In the case of e-conveyancing, the certifier is the subscriber. The required certifications for electronic transactions in South Australia are set out in Schedule 3 of the South Australian Participation Rules. The table on the slide provides a summary of the types of certifications that apply in South Australia. The certifications are: the certifier has taken reasonable steps to verify the identity of the relevant party. The certifier holds a properly completed client authorization. The certifier has retained the evidence supporting the registry instrument or document. The certifier has taken reasonable steps to ensure the registry instrument or document is correct and compliant with relevant legislation and any prescribed requirements. And the certifier has taken, or the certifier is reasonably satisfied that the mortgagee it represents has taken, reasonable steps to verify the identity of the mortgagor or their administrator or attorney, and holds a mortgage granted by the mortgagor on the same terms as the registry instrument or document. Why are certifications required? Certifications give other parties to a transaction greater certainty that the participation rules have been complied with. They also provide representations by the subscriber to the Registrar General that the instrument lodged complies with the relevant legislation, the participation rules, and any prescribed requirements. When are certifications required? A subscriber must provide the required certifications anytime a registry instrument or other document is digitally signed. The particular certifications required will vary depending on the subscriber's role and the registry instrument or document type. How are certifications given? Certifications will be set out in the registry instrument or document when it is presented to the subscriber to be signed. When giving a certification, the subscriber must ensure that it can demonstrate compliance with the certification. Land Services SA has recently held a webinar on certifications. For more information on the practical application of certifications in different scenarios, we recommend you view this short webinar. The link is available on the last slide. Where a conveyancer or legal practitioner instructs another conveyancer or legal practitioner who is a subscriber to act on behalf of their client to undertake work in an electronic lodgement network, the subscriber is referred to as an e-settlement subscriber. The conveyancer or legal practitioner is referred to as the instructing practitioner in this scenario. This scenario might occur where a law firm handles a client's work in another field of law, and the client wants that firm to complete a property transaction on their behalf. If an e-settlement subscriber is used, the e-settlement subscriber must provide the certifications as to identity, authority, evidence, and correctness when digitally signing electronic registry instruments or other documents. For further information, please refer to the ARNIC Guidance for e-settlement subscribers and their instructing practitioners, which explains the application of version 5 of the Model Participation Rules where an e-settlement subscriber is engaged. The Office of the Registrar General thanks you for taking the time to watch this webinar on certifications. Links to all resources referenced in this webinar are provided on the slide for your information. Further, as part of the transition to mandatory electronic conveyancing, the Office of the Registrar General and Land Services SA will be holding live Q&A sessions. You can register your interest on the Land Services SA website to attend a session where representatives from ORG and LSSA will be available to answer your questions. Thank you.